of International Trade Law at the University of Kansas, and he joins me now live from Lawrence. Thank you so much, Professor, for being with us on the program today. I mean, what do you make of Trump's response to all of this in imposing an additional 10% tariff? How much more is this going to complicate things?
Thank you for having me. It's an honor to be here. It's entirely predictable. The president and his team made clear all along in the months after the oral argument in November in the learning resources case that if they lost the case, they would simply reimpose the tariffs under different statutory authorities. I like to say that these reciprocity tariffs basically get reincarnated in a different statutory form. One of them that you mentioned quite rightly is Section 122. And then there are others that have been mentioned earlier in the report, 301, 232, possibly 338. So it's not a surprise at all. And in fact, the actual amount, the levy, the figures may be not exactly the same, but reasonably close. And they could even be higher, potentially, given the president's broad powers under these other statutes.
Walk us through the legality of all this. If they do reimpose these tariffs under other statutes, how legal will that process be according to the Supreme Court?
Legal. The straight answer is substantively, the president has the authority under Sections 122, 301, 232, and probably 338 to do what he wants to do. And we've seen him invoke successfully 301, for example, in the U.S.-China trade war dating back to his first administration. And we've also seen him use 232, the national security statute, in his first and now second administration. So he's got the legal authority substantively. Procedurally, they are a little more complicated than the IEEPA tariffs that were struck down by the Supreme Court because he needs reports, investigations and reports from the Commerce Department, from the U.S. Trade Representative, and that will take some time. But he will get those reports, and the result of them is probably a foregone conclusion. So he just has to wait a little bit longer on 232 and 301. And on 122, he will have 5 months, 150 days with his 10% tariffs. And then he goes to Congress and he said, will you agree, Congress, that I can continue these tariffs? And we'll see what Congress says, but I would suspect they would say yes.
And looking at the approximately $175 billion that has already been paid in tariffs to date, walk us through what we can expect in regards to the legal battles there, because we do know that around 1,000 companies are already pushing to take back the money that they've already paid.
Sure. Well, chaos might be a quick summary of it. So suppose you're a Turkish producer exporter or an importer of Turkish goods in the United States. What you will do is you will go to U.S. Customs and Border Protection and you will say, hey, we paid during the last year $1 million, hypothetically, of IEEPA tariffs. The Supreme Court has ruled them illegal. We want our $1 million back. If everything is smooth, and it may not be, CBP will then say, all right, here's the $1 million. There'll be a question as to whether or not you get interest on that $1 million. But CBP will also say to that Turkish producer exporter or the importer of record that, look, you are now liable for Section 122 tariffs of 10%. Or maybe you're liable, depending on how things go under 301 and 232, for additional tariffs. So what we give you with one hand, we will take away with another hand. Whether that comes two separate payment streams, whether that's an offset, remains to be seen. And as you rightly say, there are thousands of importers lining up with millions of dollars, maybe 175 billion total of claims. And this could be years. The president suggested maybe 5 years of litigation.
Okay, Professor Raj Bhala, thank you so much for being with us here on TRT World and sharing that insight with us.